Mar-a-Lago. Well, let's talk about this briefly. You've heard me on radio, you've seen me on Fox, maybe you haven't. Here's the bottom line. The bottom line is that what was done here was unconstitutional in at least two respects against President Trump. Number one, the warrant, to the extent any of it is available, I'm not talking about the affidavit, they're not making that available, but the rest of it. The fact of the matter is that warrant was unconstitutional. I don't care what the master did. He's not a federal judge, he's a master. Okay, he's a master who works for the court. And a lot of the work that they can't do, or the routine work, they give to the master. But he doesn't handle full-fledged trials and that sort of thing. And of course, this guy was a Trump-hating hack. You could see it on the social media, also very weird. He was part of the defense team on the Epstein case and other really grotesque cases. Well, Mark, Epstein had a right to a lawyer, I know, but that doesn't mean he had a right to that lawyer. I mean, I would never represent him, but you get the point. So he doesn't like Trump, so obviously there was some form shopping going on here. So what happened? What happened was, if you read this warrant, particularly letter C in the warrant, and you read the Constitution when it comes to the Fourth Amendment, they don't jibe. The Fourth Amendment prohibits what used to be called general warrants, if you will. And general warrants were used by the Crown during the colonial period to search somebody's home, their person, their business, or anything they wanted to. The Crown would issue a general warrant, or they would delegate that authority to their people on the scene, and they would break into the homes of these colonists if they suspected them of anything, and they can go through all their papers and search them and do all the rest of it. Well, this really was a problem as far as the colonists were concerned. So when we did write our own Constitution, we would later add this Bill of Rights. And the Fourth Amendment talks about, among other things, you have to have a search warrant based on probable cause. But even more, that probable cause has to have a particularized and specific area, thing, and purpose for investigation. The word particular is in the Fourth Amendment. In item C on the warrant, it talks about any other presidential or related material, something to that effect, that Donald Trump had from the day he stepped into the presidency to the day he left the presidency. So anything that passed his hands, anything he read, anything he may have seen, anything that was on his desk, yes, it's a general warrant. Now, just because you throw a few federal statutes in there, like the Espionage Act or the Presidential Papers Act or obstruction, those three federal statutes, doesn't give you cover to go grab whatever you want. There is the plain view doctrine. We've talked about this, but it's more problematic than that, because this was in the warrant. So even though judges sign warrants, warrants can be unconstitutional. That is so broad, I can assure you that James Madison, who drafted the first 10 amendments, drafted more than that, but the 10 that were ratified by the state conventions, he would be appalled by this because it undermines the entire purpose of the Fourth Amendment. They grabbed all the boxes. Now keep something else in mind. They were there in June. The search warrant was executed in August, 8 weeks later. So they went through the house. They scoped the house. They knew where the boxes were. They knew where the papers were. So there was certainly no need for the warrant to be a general warrant. There was no need to search Melania Trump's clothes closet or anything of the kind, That's number one in terms of the unconstitutionality of this, and that's a big deal. Think about it in your own lives, your own home. Number two, the Espionage Act, which was mentioned in this warrant and is being mentioned by all the legal analysts, because most of them are former federal prosecutors or individuals who hate Trump, or both. And so this is their mentality. But they're not constitutionalists. The Espionage Act was passed in 1917. It was later amended with the Sedition Act, the Espionage and Sedition Act, not unlike early in our history. And the reason it was passed in 1917 is because we were getting involved in World War I. A lot of Americans didn't like the idea, and Woodrow Wilson, who was not only a racist, he was a big central government advocate, and he was one of the intellectuals of the early so-called progressive movement. He didn't want people complaining and attacking him about World War I. And so they used this Espionage Act to imprison people for telling people not to sign up for the draft, not to support the war, including Eugene Debs, who ran for president of the United States. In my view, he was a commie, but he ran on the socialist line 5 times and lost, including from jail where Woodrow Wilson had put him. And he wasn't the only one that Woodrow Wilson had put in jail. And it is interesting, isn't it, that that's the early history of the modern Espionage Act, and you don't hear it discussed at all on television. It has since been expanded. It has since been expanded. It has never been applied to a president or a vice president, for that matter. Why? People keep saying that, but they don't answer the question, why? Because to apply it to a president would be unconstitutional. Why? Because the first sentence of Article 2, Section 1, the very first sentence describing the executive branch and who's in charge of it, essentially says that the President of the United States is the executive branch. There's a unitary executive. They created that. Then they created the presidency and the office of the president to oversee it. There was no Justice Department or National Archives. None of these departments existed. There was no National Archives. I'll give you an example. And there certainly was no presidential act that you had to retain papers. That was passed in 1978 as a way to get to Nixon, who claimed that his papers were private. And they said, no, they're government papers. Any of you collect old documents with signatures of ex-presidents and something like that? How do you think they're in the private market? How do you think they're in the private market? Because up to that point, they were the private papers of the President of the United States. I mean, I had a document that was the first document. It was signed by George Washington, co-signed by John Jay, who was the recipient, appointing the first associate to the Supreme Court of the United States. But this presidential so-called Papers Act, or whatever they call it, can't reach back and retroactively apply. It's now with Hillsdale College. So I purchased it to give it to Hillsdale College. Today, you wouldn't be able to purchase it. If it were a document signed today by the President of the United States, it would be an official document. But the reason I'm saying all this is because if you're President of the United States and you decide as president, still president, that you're going to take a box of books that are classified with you, whether you take them to one of the 5 mansions that the Obamas own, one of the 3 mansions that the Bidens own, like Rehoboth Beach, or anything like that, nobody can stop you. I don't care if there's an Espionage Act. Why? We talked about this. The lowest method of compliance is a regulation. It's issued by a bureaucracy. The next is a statute passed by Congress and signed by a president. But the law of the land is the Constitution. A regulation and statute cannot diminish the Constitution. A regulation and statute cannot diminish the power of the president. A regulation and statute cannot alter the first sentence of Article 2, Section 1. I don't know if there are any judges anymore who even understand this. I believe there are a few on the Supreme Court, a few justices. But in terms of the Washington, D.C. judges, the vast majority of them are hard left. There's a couple of Trump judges there who don't seem to be particularly intelligent as far as I'm concerned. But that's why you don't bring this to a constitutional head or a loggerhead, because that's a problem. So when they say the law applies to the president equally means it applies to Trump as equally as it applied to Obama, as equally as it applied to Bush. So that, I would argue, is the second reason it's unconstitutional. You cannot be accused of obstruction of something you're free to do. You want to change that? You amend the Constitution of the United States. They don't even try. They don't even try. Now, what's the other problem here? The other problem here is they went in June, and if they had all these incredibly important classified documents and they knew where they were, they had a subpoena, that's why they were there. Why didn't they take them? Why didn't they just take them? Who was going to stop them? It's the FBI. They didn't take them. Instead, they tell Trump the day later, his people, put an extra lock on that door, will you? So what happened? I was the first to point out on Monday, August 8th, the second hour during my show when this all broke, when Donald Trump tweeted that this had something to do with more than classified information. It has since been regurgitated on National Review and other magazines and newspapers and by others. But I pointed out then, and you can go back and listen, we have it on marklevinshow.com. This isn't over these documents, although this could be a pretext, obviously. They wanted to grab all his papers. I hadn't even seen the warrant then. I made the point that you can do a plain view argument. Get in there, say we saw the classified stuff, now we're going to grab all the boxes because anything else that might be in there might be relevant. And they go through it and they say, look at this. We have something else. What would that something else be? What happened between June and August that made this so urgent? For the government, they're trying to pin January 6th on Donald Trump. They're unable to pin January 6th on Donald Trump. I'm talking about the violence. If they had something, we would have seen it and heard it by now, would have been leaked, or this committee would have put it out. There's nothing. Not a single witness, not a single document, text, email, nothing. And I've told you this many times. They get one shot with a search warrant to go into Mar-a-Lago and grab everything. So, who's the U.S. attorney in charge of January 6th? He's the U.S. attorney in Washington, D.C. Who's the U.S. attorney in charge of the National Archives investigation? It's based in Washington, D.C., the same U.S. attorney. He sits down with the Deputy Attorney General who's been delegated authority to oversee this entire January 6th matter by the Attorney General, and they plot, and they scheme. And they say, we know there's these classified documents in there. Let's use that as a pretext, as a predicate. Let's get in there and grab everything. That's exactly what took place. In effect, it was a general warrant through the back door. That's what took place. It's a disgusting disgrace.
Want to see more? Sign up for Levin TV.